Why do some countries lack strong trade secret laws? In today's global economy, the protection of confidential business information is more important than ever. The question many are asking is, why do some countries lack strong trade secret laws? As businesses expand internationally, understanding this issue is crucial for safeguarding sensitive information. Recent developments highlight the urgency of this topic as companies seek to protect their innovations and competitive advantages. Trade secret laws are designed to protect confidential business information, such as formulas, processes, and customer lists, from theft or unauthorized disclosure. However, not every country has robust protections in place. One reason is that legal traditions and priorities vary. Some nations have legal systems that focus more on other forms of intellectual property, like patents or copyrights, rather than trade secrets. For example, countries with civil law traditions may not have specific statutes for trade secrets, relying instead on general contract or unfair competition laws. This can create gaps in protection. Another factor is the enforcement capacity of a country. Even when trade secret laws exist, weak judicial systems, limited resources, or corruption can hinder enforcement. Businesses may be reluctant to share sensitive information if they believe that justice is unlikely in case of theft. Economic development also plays a significant role. In countries with less advanced economies, there may be less urgency to protect trade secrets. Industries in these nations might depend more on imitation rather than innovation, leading to a lack of pressure to establish strong laws. Conversely, countries with thriving technology or manufacturing sectors often advocate for better protections to attract foreign investment. International trade relations can influence trade secret laws as well. Countries aiming to engage with major economies, such as the United States or the European Union, may face pressure to strengthen their trade secret protections. For instance, the United States has linked weak intellectual property protection, including trade secrets, to trade deficits and unfair competition. This framing can prompt countries to revise their laws to avoid trade penalties. Lastly, awareness about the importance of trade secrets may be limited in some regions. Businesses and lawmakers may not fully grasp the economic damage that can result from inadequate trade secret protection. Without clear examples or data, reform may not seem necessary. Recent trends indicate that international organizations and trade partners are increasingly focused on this issue. For example, the European Commission is now reviewing countries that could pose risks to the European Union financial system, even if they are not flagged by global watchdogs. This kind of scrutiny can motivate countries to strengthen their trade secret laws. In summary, the absence of strong trade secret laws in certain countries can be attributed to varying legal traditions, enforcement challenges, economic factors, international pressure, and limited awareness. As the global business environment becomes more interconnected, these gaps are gaining attention, and potential changes may be on the horizon.